Okay, welcome everyone to this annual webinar we have now on recent developments in Part 36, so Part 36 in the courts. And what we're looking at, obviously, is cases on Part 36, and the period we're looking at is from May last year until today. With one exception, I'm looking at a slightly older case, which was only reported more recently. And the reason I've chosen that period is the 10th of May last year was the day we did the last update on Part 36. And I see this webinar as a nice, gentle stroll through the recent cases. So we can see what's going on. And then don't panic, because then we're going to go back and look at some key points, some key practitioners' points, and in particular, the points you should be looking at to avoid problems in Part 36. So the first issue I want to consider is in relation to the construction of Part 36. And in particular, is an offer made a valid Part 36 offer? Because so that can have massive consequences. And this is one of the points we're going to come back to at the end. And the interesting case here is the case of Henderson and Jones Limited. The claimant had been successful in an action against damage for the defendant. A number of Part 36 offers have been made backwards and forwards. And the claimant was successful because it beat an offer it made, but the defendant was arguing that the offer itself was ineffective because it referred to an offer but didn't state what the relevant period was. So it goes to show the arguments that unsuccessful parties will raise in relation to the effectiveness or validity of Part 36 offers. And the argument put forward was that the letter said refer to the end of the relevant period, and the defendant said it's not a valid offer because it doesn't state what the relevant period is. He didn't define it in your letter. The claimant said, well, it's obvious because we've been backwards and forwards saying it was 21 days. So the judge, first of all, considered the rules of interpretation in relation to Part 36 offers, and said generally the court should construe it as to give effect to the stated intention. And what the court did on this occasion was saying, well, let's have a look at the previous exchanges in relation to Part 36. Now, the relevant period was not defined in the offer letter, but there have been previous Part 36 offers which did define the relevant period. So looking at those previous offers, it was said to be 21 days, an offer by the defendant, and other offers go backwards and forwards, it was 21 days. And it has that catch-all, which I don't think has any kind of validity, but say, if you think this offer is defective, please let us know by return. I don't think there is an obligation on a litigant to inform the other side that they've made a defective offer. But there you go, there it is, and it's often there. Anyway, so the reasonable reader considering this would fully understand, said the judge, the reference to the capitalized relevant period is a reference to a period of 21 days. And they know that because there was a whole history of correspondence where that period of time was referred to. And that the reasonable solicitor would no doubt have understood that although it just said relevant period and didn't say 21 days, the history of the correspondence quite clearly showed that 21 days, everyone knew that the relevant period meant 21 days. And the consequences were of it being a valid offer was that the claimant received the benefits of 1% judgment sum, interest on the judgment 10% above the base rate from the date the offer expired, cost on the indemnity basis, interest on those costs at 10% of a base rate, an additional amount which was £75,000. And the judge found that the interest rate was 10%, and the judge also accepted that costs and interest and costs should be paid, and an additional £75,000 paid. Now we're going to come back on this case later on. We're going to think about the consequences of what would have happened if there hadn't been that chain of correspondence, and if the offer had found to be actually invalid. So another issue in relation to Part 36 and the construction of Part 36 offers is the one case that didn't occur in the past 12 months. This is a case from 2020, but for reasons I don't understand, only appeared on Bailey in March this year. Henderson and Jones Limited, strangely, they're the claimant in a couple of Part 36 cases we're looking at. But related to a Part 36 offer, the claimant made a Part 36 offer of £40,000 on the 23rd of September, and the claimant clearly beat the offer when the matter was litigated at trial. However, the trial started on the 14th of October. Claimant to be effective, offer to be effective, claimant had to persuade the court to abridge time, and the claimant did a lot better. They got £94,000 plus interests. So the judge considered the rules. An offer made less than 21 days before trial did not apply unless the court has abridged the relevant period. The court said, we've got a discretion to abridge the time, but this is not an appropriate case for the court to exercise discretion to abridge time. The starting point is that Part 36 consequences don't apply if an offer is made less than 21 days before time. There is a discretion, but it's not being exercised here. When the offer was made, the claimant was professionally represented. He would have appreciated that if you wanted the favourable Part 36 consequences, you need to have made it earlier. It didn't avail itself of that opportunity. And there is a policy incentive to require litigants to make timely Part 36 offers to encourage the settlement of claim. A defendant is entitled to time to consider the merits or otherwise to accept the offer. I am not prepared to exercise my discretion to abridge time. And there are very few cases that I know of about time being abridged. So the golden lesson there is you have to get that offer in 21 days before time. So staying with that issue about questions about the construction of the rules surrounding Part 36, we're looking at whether an offer was still open for acceptance. And this was Wells and Hornshaw. It was a case where unfair prejudice was alleged, and the respondents made a Part 36 offer, both the price to be paid. And at trial, the judge said, yes, there has been unfair prejudice. There is a mechanism for the valuation of shares. Those shares are going to be carried out under a new valuation, carried out by an accountant, as an expert. Probably wouldn't need to be a second trial. The applicant will actually, now have had all that done, I think I want to rather accept the respondent's offer. And the question for the court was the Part 36 offer still open after it had been a trial? Now, if it was not opened, then the respondents who made the offer would get whatever value the independent expert for their shares had. If it was still open, then the respondents would be paying the claimant's costs, remember, up to the date of the offer, and he'd be paying their cost thereafter. And what the court decided was that there's been a split trial case, and on the particular facts of this case, the offer was no longer open for acceptance. And what the judge said was, well, the claimant argued, hang on, there's this Part 36 offer, which is still binding on me, still having cost consequences, which I can't accept. And the judge said, you've just got to accept the consequences of that. A party was being given the opportunity of avoiding judicial determination of a claim by accepting an offer, but has refused to do so, must accept the consequences of the claim being determined against them. And there's nothing unfair here in the offeree being disabled from accepting the offer once the determination desired to avoid it being made, and nothing unfair in the offer of them being entitled to derive such benefits as may accrue to him from having chosen to make it, and thus having taken the risk it might be accepted before the outcome of the claim was known. So again, it's important that you know in relation to the construction of Part 36 offers, you can lose the right to accept the Part 36 offer, or the ability to accept the Part 36 offer after a split trial. In some circumstances, you can't accept the offer but it could still go on to have major cost consequences. That was a responder's Part 36 offer, but claim the Part 36 offer, it's not delayed, and you'll be facing the additional £75,000 interest, etc. So important point to remember, important case to look at. And one thing that's going to become even more, I estimate, more common to think about in years to come is the consequences of the fixed costs of Part 36. And we had this decision earlier this year, Attersley. Claimants injured in a road traffic accident, it's submitted under the protocol, and for those who don't do personal injury work, it means prima facie is subject to a fixed cost regime. The liability is admitted, proceedings are issued, and the defendant made an offer to settle of £45,000. It's then allocated to the multi-track, and again, for those who don't know, the allocation of the multi-track means that you stop being subject to fixed costs and you are subject to cost to be assessed. So the offer is made before it's allocated to the multi-track and accepted after it's allocated. So the offer made before allocation, accepted afterwards. And the question for the court was, well, when the offer was made, it was subject to fixed cost principles, and if the claimant had accepted it then, they would have got their fixed costs. And but now the whole action is subject to summary assessment, not the fixed cost regime. Is the claimant confined to fixed costs, or is the claimant entitled to costs to be assessed up to the date of the Part 36 offer? And what the court held was the fixed cost regime is disapplied retrospectively. That meant, although the claimant had accepted the offer late, up to the date of acceptance, or the end of the relevant period, the claimant was entitled to costs to be assessed. And now, the claimant was successful in that case. Someone booking for this webinar told me the decision's been appealed. But if I was a defendant, I'm not sure I want to. Because in that case, the claimant had the protection of the all quots rules. And that means there was no set-off of costs. Now, think about the disadvantages if the quots rules don't apply, as they do here. It means that the defendant wouldn't be subject to fixed costs. So the defendant would be entitled to its cost to be assessed from the expiry of the Part 36 offer. So it's not always going to be unfair to defendants if this principle applies. It was just on the particular facts of that case it was useful to claimant. And another, if you like, quirky case or different case in relation to the rules, where it's the case of B, Tesco Underwriting. Claimants involved in a road traffic accident in August 2022, not injured, but made a significant claim for hire charges. The defendant made a Part 36 offer in April 23 and had the usual principles or usual statement in the offer that we will liable the claimant's cost. And then it was accepted on the 11th of April. The email said nothing about costs. Sometime later, in October 23, and this is important, the claimant sent in the formal bill of costs. The defendant said that knowledge of service, saying it did not contest the making of a cost order. And then the district judge made an order the defendant pay the claimant's costs. But then the defendant applied to set aside the order that he said he didn't contest. And the reason for that was that the rules had changed in the meantime. The principle had changed in the meantime. And under the rules as they applied when the cost application was issued in October, the defendant didn't have any liability for costs. But the claimant said, well, you said you pay costs when you made the Part 36 offer. That wasn't accepted by the judge. It wasn't accepted that the parties had contracted out the rules. What the offer was an agreement for an assessment of cost in accordance with the rules. And it's the claimant that's delayed after the laws changed. At the time the claimant accepted the offer, it was open to the claimant to commence cost-only proceedings. And if she'd done so before the 1st of October 2023, the cost would have been assessed on the standard basis. The argument that the claimant had an accrued right to the costs wasn't accepted. The claimant had an incoherent right to costs, which only crystallised after they'd been assessed, allowed, or agreed. And so the result was the fixed costs were nil. That upon the view I've taken, fixed costs allowed should be nil. So again, if you like, I'm not calling it a quirky decision, but it shows how important the rules are. Knowing the rules, knowing when the rules are about to change are important. If that had been issued a month earlier, the claimant would have got their cost to be assessed. Because they delayed and the rules now said costs in these circumstances, fixed costs are nil, then the claimant gets nothing. And so you've got to be very, very aware, not only about accepting Part 36 offers in time, but also getting the cost proceedings issued if rule changes are pending. It might be specific to its facts, but the principle, the fact that the claimant, the defendant said, we will pay your costs, and at the time the claimant issued proceedings, those costs were nil because of the subsequent change of the rules, didn't help the claimant. So another issue about the construction of Part 36 offers is about a rugby game. And it's the case of Albano and Clark. The claimant had been successful at trial in establishing negligence in a rugby match, serious bodily injury, and the matter was listed for a split trial with liability and causation to be tried as a preliminary issue. Shortly before trial, the defendant admitted issues relating to causation, and the claimant succeeded in trial. Now, the claimant had made an earlier offer to accept 75% of the damages sought. And as a result of the trial, they got 100% of the damages sought. And the question was this an effective Part 36 offer in the circumstances? And let's look at the offer in detail. Accept 75% of the claimant's claim for damages to be assessed. And the defendant wrote back and said, no, we don't think that's a valid offer because we've got issues as to causation, and you've got to look at the case of Seabrook and Adam. And the judge was referred to the case of Seabrook and Adam during the course of the issue about costs. So the question was, how should the offer be construed? Now, the problem is that if you go back to Seabrook and Adam, the term liability is apt to include issues both of breach and duty of causation. Now, I appeared for the claimant in Seabrook and Adam in the Court of Appeal, and that was an offer to accept a percentage of damages. But what the Court of Appeal said was that it's not an effective offer because you've got to make your point clear in relation to causation. So in this case, the rugby player case, the defendant's solicitors were right to be cautious about the price extent of the offer to settle and what it referred to. The wording of the offer did not make reference expression to breach of duty or causation issue, which was likely to be determined at the preliminary issue hearing. Rather, it referred to the issue of liability and the claim. That could refer to issues of breach of duty and causation, the latter going beyond the single issue of causation, which had been identified as a preliminary issue. So there was a need, says the judge, for precision about what the offer related to. The claimant had the opportunity to provide an explanation which would have put the matter beyond doubt and confirm that the offer related to the issues identified as preliminary issues, or by the time of trial, the issue of breach of duty alone. It then looks at Seabrook as the judge and what the Court of Appeal said. The cases this time inevitably turn heavily on the precise wording of the pleadings, the particular terms of the Part 36 offer. In order to avoid the kind of dispute which has arisen here, particularly in a low-valued claim, it's important to make express reference in the Part 36 offer to whether the offer relates to the whole claim or part of it and precise issues to which it relates. So if the offer had said, we will accept 75% of liability with causation still to be determined by the court, then that might have been affected. But here, it was too incoherent. And so the in Seabrook, if the issue is to be settled as a liability, it would be sensible to make clear whether the defendant has been invited only to admit a breach of duty, or if the admission is intended to go further, what damage the defendant has been invited to accept was caused by the breach of duty. So in the Rugby case, the offer was not effective, and so as to give rise to the Part 36 consequences. It may, however, have those consequences at a later stage, when all liability issues have been determined, but as a matter for further argument if it arises. So it might still have an effect. But not straight away. What I want to get home there is the importance of being very precise if you're making Part 36 offers, particularly difficult in personal injury cases where damages are still in dispute. You've got to be quite precise. So the next case we're looking at, and it's one of a range of cases, similar cases, is the Part 36 regime is meant to be punitive. And this is the case of Thomas Barry and Dennis Barry, and it's a horrible dispute. It's between parents and their son. They said, and the parents have been successful, the claimants have been successful in recovering sums of money they had loaned to their son. They've been a very attritional trial, a lot of very bad blood involved. They tried to mediate, made Part 36 offers, but they beat it at trial. And the defendants argued that, well, you've got your money and you're going to be doubly rewarded. And that, you know, and the judge said, so what? So what if you're going to be doubly rewarded? The Part 36 consequences, claimants' offers, are not compensatory. They are punitive and deliberately designed to encourage settlement. However, the test was whether it was unjust for the defendant to face the Part 36 consequences, and the burden was on the defendant to show it was unjust, and there was nothing here to persuade the court it was unjust for the normal Part 36 consequences to apply. The principles to be applied, the key ingredient were set out in the case law. A key ingredient of the Part 36 code is provide additional incentive to accept reasonable offers and avoid or end unnecessary litigation. It's intended to penalise a reasonable refusal to accept an adequate offer. And these are deliberate incentives, said the judge. The argument that they've got their justice by succeeding in their claim, they should not be doubly or over rewarded. But these are not penalties. These additional amounts are deliberately added to the new cost regime to strongly incentivize offerees to accept adequate, reasonable offers and to penalize. And the defendant came nowhere close to persuading me that it would be just not to order the mandated additional amount. The defendant, that's the son, was not interested. His case failed in virtually every particular trial. And the claimant solicitor argued was just to make the order, but that's not the test. The claimant doesn't have to establish it's just. The defendant has to establish it's unjust. It is not unjust. This is the paradigm case where the additional amount should be awarded. And so the claimant's got all the additional interest, benefits, and the cap of £75,000. And another case about it's effectively a claimant's offer, it was about counterclaim, and where the court considered the question of unjustice was the case of Southbank. Now, the claimant brought a claim for a declaration that a lease and the lease were void or voidable. There was a separate relating claim by one of the defendants for unpaid rent. The claimant's claim failed, but the claim for unpaid rent succeeded. And the offer for rent, the property's offer for rent, was not beaten at trial. So the landlord who made the offer had on the face of it the Part 36 benefits. It was the claimant's Part 36 offer, and the court was determining whether or not the normal consequences could comply. Well, first of all, the offer was compliant. and the court had to consider whether it was unjust. Was the usual order that the part 36 consequences apply unjust? And the question, the party, the tenant who had not beaten the offer said, well, it put me in a dilemma, because if I accepted their part 36 offer, I had a problem in my own case. I was in a dilemma. But the judge said, the question's not whether you had reasonable grounds for declining to accept it, but whether the usual order following beating the part 36 offer would be unjust. And it prevented you with a problem. But so what? I'm prepared to accept the part 36 offer presented you with a dilemma, but your main claim was never going to succeed anyway. It didn't succeed. And so you rely on your main claim as an indication of justice. It's just impossible. So again, we see that draconian part 36, draconian, but yeah, it's meant to be draconian. It's meant to be punitive, applying even though you put a party into a dilemma. And the next case we're looking at is a case decided by the Court of Appeal about an issue in the Court of Appeal. Can a party offer too much? Case of Majid. And but the issue was whether or not the claimant could recover car hire charges in a case where he'd been driving around despite his car having no MOT. And the first instance judge found that he couldn't, and on appeal, the Court of Appeal found that he could. So, well, far and good, the claimant won his appeal. But prior to the offer, the defendant made a Part 36 offer of £30,000, which was more than the claimant was seeking and more than the Court of Appeal could ever award. And the claimant did not accept that offer, and the Court of Appeal, and because the offer wasn't beaten on appeal, even after the Court of Appeal assessed damages. So the Court of Appeal said the normal principles apply. Part 36, the claimant's going to receive its costs up to the date the Part 36 offer was effective. And then the claimant, although successful at the appeal, was paying the defendant's costs. And what the Court of Appeal said, it wasn't a test case. The claimant was saying, well, we need to find this issue in the court. It's an important problem. It pops up regularly. But it wasn't set down as a test case at all. And the parties were free to settle this case, and the claimant's own best interest would have been served by simply accepting the defendant's Part 36 offer. You said to the claimant, look, here's more than you're going to get. It's clearly in the claimant's best interests to accept. So the parties could have settled the appeal, and it wasn't a test case. It could have been settled, and a defendant can build in a margin of safety. There's nothing in the rules to prevent a defendant from building in a margin of safety in an attempt to persuade a claimant to accept the Part 36 offer. And the materials available to the court could not justify a conclusion that the Part 36 offer was not a genuine attempt to settle the case. And my colleague, Stephen, who argued the case, had this interest in what he sent me, the code of the judgment. I'm not sure it's publicly available. It's on my blog. Makes the point. A party that wants to exert maximum pressure to settle is entitled to do so by offering more in monetary terms than the claim could possibly be worth. Another point that's come up several times over the past year is Part 36 offers in cases where there's no money involved. And Grierson was about a will. In this case, the judge found in favour of a will made in 2020, pronounced against the validity of a will made in 2022. And the offer made was that the 2020 will be omitted to probate, the 2020 will should be varied, and in addition, you, the defendant, shall receive an additional pecuniary legacy of £20,000, and the defendant will be replaced as executor. And what the judge found, although there's no money involved, it's all about the validity of the will, the offer was beaten. It's the least as advantageous to Duncan as proposed to contain the Part 36 offer. It included the replacement of Robert as an executor, which is something important, which couldn't be achieved from the judgment, only by consent. However, the offer included an additional pecuniary legacy of £20,000. If Robert had accepted the offer, Duncan would have been financially worse off than the terms of the judgment. So the question was the offer at least as advantageous to Duncan? Robert should have accepted the offer to Robert. Robert should have accepted the offer rather than require this matter be taken to trial, and his failure to do so led to substantial costs being incurred. And the cost consequences were Duncan was entitled to the cost on the indemnity basis from the 24th of April 2024, interest at 10%, 10%, an additional sum being 10% of the amount awarded to Duncan in respect of costs. So moving on to Part 36 and cost budgets. And here, I want, just before we move on to the case law, I want to look at the rules slightly because there's a difference in Part 36 consequences for claimants' offers and Part 36 offers. Now, if a claimant fails to obtain a judgment more advantageous than the defendant's Part 36 offer, the claimant has to pay costs from the date on which the relevant period expired and interest on those costs. But if a defendant fails to pay a claimant's Part 36 offer, the claimant gets interest costs on the indemnity basis. This is important. Interest on those costs, and then a 10% damages, which additional damages, a figure not exceeding £75,000. So the point I want to make here, indemnity costs only apply to claimants' offers. And that's important because a lot of people think it applies to both sides' offers. Some case law we've looked at in previous years where the defendant made an offer and said, can I have indemnity costs? The importance of that in relation to cost budgets is this, and we'll look at it again later, is that if a claimant meets their own offer, then cost budgeting or for whatever period, for the relevant period, may not be relevant because cost budgeting takes place on the standard basis and the claimant's getting the cost budgets, its cost assessed on the indemnity basis. Now, all kind of issues following that. But what happens if a defendant, a claimant fails to meet a Part 36 from a defendant? How relevant is the cost budget? And that was considered in A&V building. Claimant failed to meet a Part 36 offer. Remember, he's only paying costs on the standard basis, and the defendant was seeking much more. And now for the issue in question, the period in question, the budgeted costs were $82,000, and the costs allowed were more than that, but only slightly more in the context of litigation, about £6,000 more, £6,500 more. Because the judge said, once a case is budgeted, it's for the receiving party to show a good reason to depart from the budgeted costs. And this was the high bar. And in relation to many of the items that the defendant tried to get outside the cost budget, they weren't accepted. It also said, this is important going forward, the party deciding whether to accept a Part 36 offer is entitled and should be expected to make such a decision on the basis that the cost estimate is complete, competently and thoroughly prepared estimate of offering parties' future costs and an accurate statement of good faith in the costs already incurred. So it's important there for claimants who are accepting Part 36 offers late to say, be able to point to this decision and say, okay, we'll pay costs on the standard basis, but there's got to be a good reason to depart from the budget. Again, I want to move now back to another decision, which comes to our favourite subject, which is the non-monetary Part 36 offers. And this is again another case in relation to probate and death. There was a order that certain transactions were made in contemplation of death. There was no direct claim for monetary relief. The claimant made a Part 36 offer. The judgment of the trial more advantageous to the claimant the offer they made, and the judge considered. So the offer was give the claimant the house, furniture, and personal chattels of a particular house and all bank accounts, and it was agreed that the offer was a claimant's Part 36 offer. So the test of this was it more advantageous or at least advantageous? It doesn't mean only money has to be on display. So it was a valid Part 36 offer and did have effect. So there were the cases up till last Thursday or Friday. I wanted to talk about in Part 36. I'm going to go back and look at the practical consequences later. Now, I sent him the slides and then had to get them or revise them. Because this was a case last Friday, bang up to date in all this, unless this doesn't come out while we're doing the webinar. H&P Advisory Limited. And basically, it's all about services provided to large banks. Claimants brought an action claiming money is due for work done on a quantum merit basis. Basically, they tried to put a deal together for the defendant, and the deal went ahead, but there was no agreed fixed terms. So the claimant said, "We want money." I think they wanted £40 million. The defendant said, "We don't want to pay you that," but the defendant made a Part 36 offer of £2 million. And the judge went to trial, and the judge said, "I think the claimant's entitled to something, and the best way of doing this is looking at the minutes of the board meetings and seeing what the defendant thought they were worth." And it was the defendant that said, "Yeah, they probably provided services of £2 million, so therefore I'm going to award the claimant £2 million on a quantum merit basis." So it gets back before the judge, and there's arguments about interest because the defendant's Part 36 offer is actually for £2 million plus interest. Unfortunately, they made quite reasonable assumptions, as we'll see. After the calculations of interest were done, it turned out that the claimant had not beaten the Part 36 offer. And the claimant's argument, remember this is a very sophisticated was that the normal Part 36 consequences should not apply because we didn't know until we got to trial or until the hearing was on, that this £2 million thing had been considered. It's done on the basis of the defendant's evidence, and it's unfair on us to impose that kind of consequence. And the judge, almost scathing, and they said, "Wait, you're a sophisticated commercial organization. Actually, your job to work out this kind of thing, and you could have worked this out for yourself." So the claimant saying, "Feel sorry for us, Gov. We're just, you've only got £2 million, and it would be unjust to make such an order because we couldn't make an informed assessment between it was $2 million because we didn't know about the internal discussions of the $2 million figure." And the judge said, "This is actually an absurd argument. An investment bank whose entire business revolved around the delivery of transactional advisory services for value could not have been reasonably expected to value its own services without access to the internal deliberations of its client. I therefore reject this argument. There is no injustice here. And this is, I think, important, almost all Part 36 offers are necessarily made before the parties to the offer for the disclosure of the side documents. The finding that this constituted injustice was that the effect of vitiating the Part 36 regime. And the fact that you've only not beaten the offer because of interest makes no difference. Because if you've been out by a penny, even a penny, then the Part 36 offer would not have been met. Where the amount offered is equal to the principal claimed, and the only debate is whether the amount of interest offered by the defendant is equal to the amount to which the claimant is entitled. I'm not going to disturb the normal ordinary consequences of Part 36. So the claimant sues, I think it's $14 million, gets $2 million. It's a heated and lengthy trial. It only gets, in fact, the claimant 50% of its costs leading up to the Part 36 offer. It's paying the defendant's costs thereafter, albeit on a standard basis. So the commercial advantage, if any, to the claimant must be very minor, even on $2 million, $2.3 million with interest. It's probably paid out in cost and will pay out in costs. Probably what the whole of that $2.3 million. It'd be interesting to see whether or not there was a balance in favour of the claimant. So as I said, that last or most recent case shows how strictly part physics is construed. So we've looked at the dozen or so cases over the past 12 months. What can we learn from them? Well, I think I'm not going to go through all the cases again. I'm just going to pick out the key bits. Henderson. Look at the points the defendant took on the validity of part physics offer. You didn't say 21 days and therefore it wasn't a valid offer. And what were the reason those points were taken? It's because there was a lot of money at stake. Interest on the judgment sum, 10% above base, cost on the indemnity basis, interest on those costs, and £75,000. There could be easily £250,000, £300,000 just in those cost consequences. And what would have happened if there hadn't been that course of offers where 21 days had been mentioned? So it's very important that you make sure that your Part 36 offer is compliant. The claimant was fortunate in that case. That's no reason for people to relax and think, I don't have to worry about the construction of Part 36. Make sure I tell people to use the form always. Don't go busking on your own. Don't try having your own better Part 36 offers. Use the form, use the wording, and be very, very aware of the points that can be taken in relation to validity of Part 36 offers. Because the claimant's solicitors, if they'd won that argument, could have lost their client at least £75,000. As I said, maybe £300,000, maybe even more. As an aside, what would have happened if the claimant's solicitors hadn't told, the defendant for you in that case, hadn't told the defendant to make a Part 36 offer? No, the claimant's lawyer, there would have been major problems. So, Henderson and Jones, time for making an offer was not abridged. So make your offers early. Remember, 21 days before trial, it's unlikely you're going to get any time abridged. Case of Wells, it's impossible to lose the ability to accept a Part 36 offer, even though the offer is still effective. And the case where they were arguing, I can't accept the offer, it's still valid against me, that's unfair. It doesn't matter. You had the chance to accept it, you didn't. The case of Albana, if you want to make an offer on liability, you have to make it quite clear what your offer is. Does it cover causation as well? Very difficult relation, not impossible, but you've got to be very clear about the terms on which you're making the offer. And in the case of Thomas Barry, remember, it's unfair for me to have to pay the Part 36 consequences. It's quite clear, and I'm sorry, I know we don't use hammers and gavels in British courts, but the point I want to make there, the Part 36 regime is meant to be punitive. It's difficult to escape the consequences. The test is not whether the imposition of the penalties is just, it's for the other party to show they're unjust. The other case I want to look at is the Margid case. You can overoffer. And the claimant in that case would have been better off accepting, personally, would have been better off accepting the £30,000 decision. I mean, it's difficult to see how anyone advised the claimant could not have said, take the money. He was obviously being run for a purpose other than the claimant to prove a point. But the consequences were that the claimants were not ended up paying the cost of the appeal, the cost of bringing up to the appeal, and since leading counsel were involved, then it may have been quite high. In the case of Raymond, remember, and a couple of other cases you've looked at, you can still make effective Part 36 offers in non-monetary cases. The court will look at the facts and see whether or not the offer is more advantageous to the recipient than the award made at trial. So, the H&P advisory case, the claimant did not beat the Part 36 offer by a waiver whisker because of the way that interest was calculated. But still, that whisker was important and the normal Part 36 consequences applied. So, 1 point, that's the kind of review of this year's webinars on Part 86. If you want to watch the previous webinars, I think there's 3 years, this is the 4th year, I've put links on there to the various points. The penalty you have to pay for watching this webinar is I just got to remind you of the clerks. You've got Harry and Louis, the cost clerks at the King's Chambers. And I've allowed 10 minutes of questions because often I do get lots of questions in the Part 36 webinar. Where a Part 36 offer is made prior to proceedings being issued, should the Part 36 offer be repeated once proceedings are issued? No. Part 36 offer can be made before the issue proceedings. Why would the defendant make an offer without prejudice to cost over cost except as a Part 36 offer? They asked the defendant, I think, anonymous attendee. They do that, and I don't know why. There may be a rationale. I don't understand it because you don't get the benefits. Now, can a party? So the bit not criticizing. It's just the typing's a bit askew here. Can a party make a valid Part 36 offer pre and post legal action on claims that are within the category limit, i.e., £10,000? What Part 36 consequences apply? If not, how best can a party? Part 36 claim does not apply. Part does not apply to actions within the small claims track. So they're saying they're £10,000. That's not the small claims track limit in a lot of cases. In housing cases, it's £10,000 for disrepair or inconvenience. Personal injury cases, it's whether pain and suffering is more than £1,500. But generally speaking, if a case falls within the small claims track, Part 36 does not apply. Oh, yeah. Sorry. I know I was attending. You did put your toe power right in the next question, but I got the answer. I have received a query from a claimant solicitor asking whether a Part 36 offer can remain open for acceptance without any cost penalties after the expiry of the 21-day period. Julian, that's actually can happen. In some cases where, for instance, you've got personal injury cases where there's an uncertain prognosis, we don't know the answer to certain points, the court said claimants or defendants even can ask for an extension of time and it can be granted, but it's totally up to you. It may be issue relevant as to conduct, but there's some of the cases indicate, not cases from this show, indicate that a party can apply, can ask for it not to apply. The court can't order it, strangely. But the court, if the claimant wants to protect itself, what the claimant should do then is apply for a stay. Now, if you're using the Part 36 form, what wording will you use to ensure that the interest and damages cost, if Part 36 consequences apply, included? I wouldn't mess with the word. I don't understand I don't understand the question. Maybe me being obtuse, sorry. You put a figure, and that figure is inclusive of interest. I don't think you can say in your, or could say in the offer, property offer, that we're going to get extra interest, because that's the inevitable consequence in the rules of Part 36 applying. So this is disrepair claims, so all set out in the Part 36 offer. Gillian, I'm not. Oh, is that the? I got to read 2 questions together. Clearly, it's a query from the claimant solicitor. Can you remain open? It's a disrepair claim. It's all set out in the Part 36 offer. Gillian, it's a matter for you. The claimant, what the court cannot do is make an order for a different consequence. If the claimant wants to protect itself, it should apply for a stay. Yeah, so I'm moving over to the chat function. As a lot of people say, thank you. Some people are asking questions there. Is it possible to make a Part 36 offer with the cost budgeting process? Yeah, no. Oh, I'm sorry, William. Yeah, you say it's bat fingers. Yeah, sorry, it was an accident. I do apologize. Is it possible to make a Part 36 offer with the cost budgeting process? No. You can make offers in the Part 36 process, remember, but there's not going to be any judgment. You can make offers. We've got the whole regime for the budget discussion reports, and there are some cases where the court said you've been asking for too much, it's ridiculous, you're paying the cost of this, but Part 36 doesn't apply to cost budgeting. There is a process in place which is supposed to, the budget discussion report, but you can't do it in the budgeting process. You can do it in the assessment process, but not in the budgeting process. Okay, I'm just checking because they keep coming in a manner. I think I've got all the questions there that have come up on the question section. I can't really move over to the chat section and answer the questions there because there's so much there. I've done that. Okay. So thank you very much for watching. This case will, are parties required to respond to a party itself? And no, you can ignore it. You can ignore it at your peril. You don't have to say yes or no. Right. You don't have to respond at all. It's silly not to, but there you go. If a receiving party makes a party offer that was rejected, the paying party makes an offer that was rejected, receiving party makes new party section, the receiving party wins and beats the first and second part 36. When does interest apply? Well, from the first effective part 36 of them. Sorry, Wayne, the question's a bit ambiguous. I think I know what you're saying, but the receiving party wins and beats the first. It's the first effective part 36 offer. I'm not quite sure basically which one was affected. Is there a precedent wording for making the part 36 offer the user's base? Yes, there's a form in anonymous attendee. There's a form available on the internet which for part 36. This is an interesting question. Where a contract includes a provision for costs and expenses to be paid on the indemnity basis, and the contract provides the fixed cost regime is excluded, when the claimant makes a part 36 offer and the judgment beats the part 36 offer, how the court deal with costs and the contract on the part 36 regime? I can't offer a definitive answer to that. But the answer is usually under the contractual provisions. Because the party, if it is a proper contract and not one imposed, remember there's all kinds of consumer protection legislation about imposition of unfair terms. If it is a proper contract between equal parties, then it's usually the contractual terms. But the contractual terms won't, or may be subject to a large degree of scrutiny if they're imposed on a consumer. Okay, this is an interesting question for William. A party makes a part 36 offer monetary and non-monetary relief, beats their monetary offer and fails to beat their non-monetary offer. Which is the position on whether this is more advantageous or not? There's a case on this last year or the year before, CCC in Sheffield. It's going before, we've got a judgment pending in the Supreme Court on a different matter. And in that case, the claimant had made an offer to settle in relation to, it's a serious injury case for a childbirth injury, in relation to a monetary offer and had made, I've got to get the right way around, and had made a different offer in relation to periodical payments. And what the court held was that although they'd done better in terms of pounds, shillings and pence, or pounds and pence now, in relation to the monetary claim, they'd done worse in relation to periodical payments, not non-monetary, but the same thing, and therefore they hadn't beaten their own part 36 offer overall. So you've got to beat both if you look at the CCC Sheffield decision at first instance. But the other question may be, I think that's the general principle. Yeah, I'm not sure I understand this question, Madhu. A part 36 offer made to accept K plus cost of assessment. Or the cost of the set. I'm not sure I understand. It's probably me being obtuse, Madhu. I don't understand the question. A part 36 offer should give a definite sum because it's ambiguous, and I think it's the ambiguity means I can't give an answer. Okay, I'm going to call time now. I'm sorry to people who've put questions into the chat section. I've encouraged you to move across to the question section. And as this webinar will now go onto YouTube, if you should ever feel need to read it or look at it again, it will. I understand the PowerPoints, if they've not been sent out to you, will be sent out in the near future. So thank you very much for watching. I hope to be doing one of these next year. Later on in the year, I'm planning to do a specific webinar on avoiding the pitfalls of Part 36. And some of the issues you've raised there, questions you've there, will be dealt in that webinar. So basically, watch this space. Thank you very much.